So this is Dr. Prabha Kotishwaran. I'm a reader in Law and Social Justice at the Dixon Poon School of Law at King's College London. I'm a co-editor of Beyond Trafficking and Slavery, which is an editorial partnership between Open Democracy and researchers from Africa, Asia, America, Australia, and Europe. At BTS, we seek to challenge the anti-sensationalism of mainstream media representations of exploitation and domination relating to modern slavery. But beyond that, we're also interested in how do we engage with law and policy makers. In other words, how do we translate our critical voice into one that's meaningful in a public arena? And with that in mind, we are here today to discuss the Modern Slavery Act of 2015, which was passed by the British Parliament in March 2015 to eradicate modern slavery in the UK. And joining me today to discuss the Act is Dr. Peter Ramsay, who is reader in criminal law at the London School of Economics Law Department. So Peter, thank you very much for joining us. You're an expert in English criminal law. So tell us a little bit about your research.
Yes, my research is definitely focuses on English criminal law. And I've been particularly interested in understanding why, or identifying patterns in recent criminal legislation and understanding why the criminal law is, why we get certain forms of criminal legislation, new forms, rather than being directly so interested in the content, although I suppose I'm interested in that as well, so because they're forms of the content. It can only be the form of the content. So new criminal legislation, and particularly what characterises the last 25 years or so in criminal legislation, and how that's different from the past and why it's changed. However, that said, I should say that in recent years, having started by looking at antisocial behaviour orders and the expansion of the scope of the criminal law to cover a wider scope of behaviour than perhaps it did previously. I've more recently been interested in trying to situate those developments in a broader theoretical grasp. So my own work recently has been more focused on understanding criminal law theory, but not just because I teach criminal law theory, though that's true, but in order to situate these developments in the broader academic theorising of the criminal law. So my interest is in that context. Why are these laws developing, and what do they tell us about, particularly about the British state? What do these types of laws and their expansion tell us about the changes in the British state? Since these are criminal laws and they're the bottom line of state coercion, they're the authoritative version of our normative order, and so by analysing the changes in them, I'm trying to get at what's changed in that normative order, understand that.
So I take it that your work is also related to how criminal law interacts with questions of citizenship. Am I right?
Very much, yes. So I should, I suppose, in more detail. So criminal law theory, the dominant academic theories of criminal law are those of moral philosophy. So the problem is seen as a moral philosophical problem. Whether someone should be punished and what they should be punished for and how much they should be punished is seen as a question of the ethics of that kind of response to a wrongdoing, and normally that wrongdoing is understood as a wrongdoing to the victim. Now that's not, there's other views there, but whereas the theory that I'm in the business of developing, which is still work in progress, would be a political theory of the criminal law, in which the question isn't what's the morally appropriate thing for the state to do, but the question is what's the constitutionally appropriate thing for the state to do, and to understand crime as a constitutional problem, not in the lawyer's sense of constitution, but in the sense of the problem of constituting a body politic, and therefore as a question of citizenship. So on my account, the criminal law, since it's as a matter of positive law, in fact, it's an action of the state. It's a plea of the Crown, and the initiative is controlled by the Crown, by the Attorney General. that means that it's the state, the public interest in the final analysis, which determines whether or not prosecution will occur, and that those are the interests that are at stake. So it seems to me that if that's a proposition of law, it's not a normative proposition. That's what the law tells us. And so that suggests to me that all the duties, the obligations that we're under in the criminal law are obligations to the state, and so the criminal law is one and a very important dimension in which the rights and duties of citizenship are established. So just to be clear, since criminal lawyers characteristically misunderstand this, it's not a question of the jurisdiction of the criminal law to whom it should apply. It's a question of what the public wrongs are, and they seem to me to be what we determine, what the legislature or the courts determine is a public wrong worthy of citizenship, must be an aspect of the rights and duties of citizenship. That it also applies equally to non-citizens is a separate question. So I'm not suggesting that the law ought to treat non-citizens and citizens differentially. I think there's good democratic reasons as it happens why non-citizens are treated equally, or ought to be treated equally by the criminal law. But the scope of the criminal law, the public wrongs that it consists of, are analytically, by definition almost, aspects of the rights and duties of citizenship. And as they expand or contract, we're seeing changes in the contours of the citizenship and the relation between the individual citizen and the state. So that's the kind of broad theory I'm working on.
Yeah, it's fascinating, and I think we'll revisit this theme towards the end of our interview today. So in the early years after the Palermo Protocol on trafficking was adopted, so a very particular context in which to apply your scholarship, trafficking was viewed by many experts as manifesting a moral panic. So initially it was over sex trafficking, then it sort of creeped onto sex work, and today it's much more a conversation about modern slavery. You know, there are reportedly 35.8 million slaves around the world in various sectors like shrimp farming, the cocoa industry, cotton fields, brick kilns. We also have ice slaves. So all of this is supposed to arouse our indignation, you know, talking about public wrongs. And so if you were to look back at the history of the criminal law in the UK and around the world, how has the criminal law responded to these sorts of moral panics?
Well, I have a very specific view about moral panic, which maybe I should explain first before thinking about that question. If we take the slavery trafficking question, about which I know relatively little, it's not specifically been an area that I've focused on, and even less about the Act, but it does look like an immigration panic to start with. It's part of the general anxiety about immigration, which leads to strengthened immigration control, regulation, and indeed criminalisation of immigration law. And then that leads to the tighter and the tighter control and the rhetoric around it, and the criminalisation of unlawful immigration, then leads to organised crime involvement in labour migration, particularly at its more marginal ends, where people won't have the resources to get around the immigration control themselves, and that then leads to crime panic. Then that produces a panic about organised crime being involved in sweated labour. Now, I see that has some of the structure of a moral panic, but my own view is that moral panic doesn't quite capture more generally what's been happening in the last 20 years or so. This view is draws heavily on work by a guy called Stuart Waite, a criminologist in Scotland, who wrote a book about antisocial behaviour, which was an issue that I researched quite heavily. And he pointed out that in the past, the moral panics that Stanley Cohen had talked about, the mods and rockers and the street mugging of the early 80s and all of that, were driven by a reassertion. What they invoked was a reassertion of a traditional idea of a substantive moral community. They invoke the values of patriotism, race and nation, family. If it was abortion or something like that, single mothers, it would be religious morality, and so they invoked those old substantive traditions, morals, you might say, and they were tended to come and go. So we called them panics because they burst out, and sometimes they produced weird and wacky legislation. The most notorious example being the Dangerous Dogs Act. So there's a panic, and then there's people who've got pit bulls, so we have to have an act. But that's legislation that then quickly becomes effectively, I mean, maybe it's occasionally used, but it was entirely symbolic legislation. But also the general reaction of bien-pensant feeling, of liberal feeling to those moral panics was one of disdain. They've got their knickers in a twist again. And so the thing would pass away. It seems to me that Waiton is right to say that now panic is the permanent condition of state actors. And they move, and indeed I suspect that's more broad in authority. If you obviously you can edit this out, but if you look at university management, they're in a permanent panic, and they're getting that from above. So I agree with Waiton that panic is institutional. I think he calls it institutionalized panic, which is an interesting phrase. So in institutionalized panic is the new normal, and that now here I think the result is legislation which is much more pervasive, long-lasting. It doesn't produce the same reaction amongst liberal thinking. Liberal thinking is much more open to it. And the reason for that is it's not driven by the old substantive morals. You will look long and hard for patriotism or family values or religious morality in any contemporary drive to greater use of the criminal law to respond to a social problem. What you will find all the time is harm prevention as the driving force. And in that, having, from the point of view of a criminal law theorist who's looked at all those debates about the limits of the criminal law and the justification for criminalisation, it seems to me that this represents this shift from the attempt to assert moral values that were derived from traditional, we might call them patriarchal, in the sense derived from the idea of a traditional central authority, a religious monarchical authority, that's been unable to sustain itself, and in its place this harm prevention based panic has come about that's much more permanent. And in that it represents the ideological victory of Herbert Hart over Patrick Devlin. That Hart, it has, not only did he win the fight in the 60s in the argument over the decriminalisation of homosexuality, but the whole of the institutions of public life have gone over to that position. And that seems to me to be an enormously significant change, and is why we are seeing this pattern. So I can see why people see moral panic, because there's this pattern of panic which formally maps onto the moral panics of the past. But now it's institutionalized, it's permanent, and it's not driven by the old moral values. It's driven by anxiety about harm and fear of harms. And in a way, I suspect that that's why it's permanent, because as proponents of the harm principle in legal theory have always acknowledged, going, I think, right back to Mill, but certainly Feinberg, the possibility of harm is in all human conduct. All human conduct risks harm. So once you adapt your moral order to the prevention of harm, you're going to find risks of it everywhere, and that drives. So then, when anybody comes up with one, says, "Oh, look, there's a risk of harm down there," then, what are we going to do? Well, something must be done. Is the cry goes up, and there's something that's normally done is legislation. So yeah, Stuart Waiton calls this amoral panic. I'm not so sure about that term. It's charming. It's moral panic, amoral panic. I think demoralised panic would be slightly closer. That institutionalised character of it, the permanent anxiety, the institutionalisation of permanent anxiety indicates a demoralisation. And I suspect, ironically, it is of course the very collapse of the old moral values that's demoralised us in the absence of any alternative, so that our institutions are in permanent anxiety about the possibilities of harm. So is that an answer to your question? That produces a lot of legislation, and it looks to me on the surface, not knowing this in debate in detail, it looks like it's produced the Modern Slavery Act.
Actually, that's a fascinating lens through which to understand the development of the panic in relation to trafficking. As I mentioned, it started off with sex trafficking. Your typical sort of moral panic: we have to protect our women and and our families and so on. But has traversed to this panic around modern slavery, and that sounds much more demoralized, but much more permanent and pervasive, because you can see it in every product which is in this room right now is a source of slavery, and we're all buying slave labor in a certain sense. But I think that's a very interesting observation.
Yes, and I suppose, I don't know, this is a speculation because you know this territory better than I, but in the past, a panic about something to do with sex, trafficking people for sex, would have been formulated in some patriarchal anxiety about sexual license. That would have been the way that prostitution and all of this would have been seen. Whereas now it's at least formally constructed as an anxiety about harm to the women who are trafficked. No doubt, as we'll come on to, it's actually the women who are trafficked who feel the rough end of all of this. But the formal ideological terms, moral terms in which the whole debate is discussed have flipped over.
No, I think that's absolutely right. And harm is the terrain on which actually sex workers are fighting back as well. You can see the Canadian litigation around Bedford to say, well, if you want to reduce harm, why don't you decriminalize, right? So I think it's a very fascinating conversation, and it doesn't actually help that feminists ourselves have not resolved the question of, is this harmful or not? And so this very rich debate around harm is also gone in very different ways, and it was present at the birthing of the trafficking protocol, very much this deep divide between feminists. So, and I think you're right. So this document, represents panic in all sorts of different ways, and indeed it's 73 pages long. So is that typical for criminal laws these days in the UK?
Interesting, actually. When I read the question, I thought, that's about right, but I think it is. It's not actually. There's longer. It's not typical. Several of the ones that I had a look. The Fraud Act is shorter. The Bribery Act is shorter. But what did I get? So the Modern Slavery Act is 62 sections and 5 schedules. The Crime and Disorder Act of 1998 was 121 sections and 10 schedules, so double the length. The Sexual Offences Act of 2003 was 143 sections and 7 schedules, so that's even longer. The Criminal Justice and Crime and Courts Act, just sort of 2015, 98 sections and 16, so a bit longer. So it's in the middle, actually, for length. They come longer. I don't know about in pages. They come longer in the number of matters they think they're dealing with, but they also come shorter. So I'd say it's roughly in the middle.
Okay, that's very interesting. So what is your view of the way in which the core offences have been defined under sections 1 through 4? So it's really only 4 sections that are that define the offences that the Act applies to.
Yes, well, they are vague and broad in the contemporary manner, and in that then not unlike legislation, criminal legislation more generally. I was particularly struck by subsection 4 of section 1. So when the court is required to determine whether a person is being held in slavery or servitude, or required to perform a forced or compulsory act, regard may be had to all the circumstances, and the circumstances, for example, any of the person's personal circumstances, but then some examples are given, which may make the person more vulnerable than other persons. Any work or services provided by the person within the circumstances which constitute exploitation. So, and then when we look at exploitation, it's all fairly vague. Another interesting, and here it is slightly different, section 4, so that's kind of, that sets up a certain vague character, which I'll come back to, because I think the political content of this is really interesting. Section 4 then adds a whole set of preparatory offences in effect. Where's section 4? Here we go. No. Yeah, section 4, committing an offence with intent to commit an offence under section 2. So It's very characteristic of contemporary legislation that the offences that are enacted are what, in my theoretical work, it's not a term unique to me, but it's certainly one that I promote, are pre-inchoate offences. So they are offences of doing something with the intent, an ulterior intent to commit a criminal offence. That's very common. What's more unusual here is that they are themselves criminal offences. So if you commit any criminal offence with intent to commit a slavery or trafficking offence, that's unusual. It's narrowed it down a little bit. It would be very interesting, as a theorist, which is what I primarily am, it's very interesting to think about the possibility of presumably some of the offences that could be committed preparatory to the slavery offence would themselves have preparatory offences. So if you committed, say, a preparatory offence with respect to a child sex offence, facilitating a child sex offence, which is a purely preparatory pre-inchoate offence, and that was done with the eventual intention to commit a slavery offence, that would be enough, wouldn't it? So you're going to have very remote conduct that's extremely remote from any eventual trafficking offence that will be included. So leaving aside, so we have this vaguely characterised offence, and then added to that we have a hugely broad scope of preparatory offences, which would capture conduct a long way distant from any actual offence committed. Now, I assume, again, I've only read the Act very briefly before doing this, that the intention there is to increase the penalties up to 10 years, effectively, for any offence that might be committed, and that's that use of what I would characterise as a pre-inchoate offence is a common technique for raising sentence levels in the preventive orders, which we'll come back to. So the preventive orders use that technique of covering, so if you're banned from doing something under the terms of a preventive order, that's also a criminal offence. Quite often the penalty for breach of the preventive order is more serious than the penalty for the criminal offence, but the courts have held that in the right circumstances you can get the higher penalty for the breach of the order. So something similar is going on here, I think, to that. So it's in line with other developments, it's entirely in line with, it's what I suppose what I'd expect. Entirely, there's nothing that surprising there. But being a theorist and very interested in the content of the definitions of substantive law, I mean that's one of my major areas of interest. There's no other word for it. The ideological content of this offence definition is fascinating. So, is it subsection 1.5? I think 5. Yes. So we have an offence that's forced labour, but the consent of a person, whether an adult or a child, to any of the acts alleged to constitute holding the person in slavery or servitude or requiring the person to perform forced or compulsory labour, does not preclude a determination that the person is being held in slavery or servitude or required to perform forced or compulsory labour. So you can consent to being forced. Now, we have this, there's in relation to sexual offences law, there's a question mark over when a person to consent has to agree by choice and have the freedom and capacity to make that choice. So it's possible that a person chooses and yet doesn't consent. But this takes a further step and says it's possible that a person is forced even though they consent. So the Sexual Offences Act, although it takes a little step down that road, it still requires proof of lack of consent before you have a sexual offence. Here, what's forced now no longer requires proof of lack of consent. So there's, I don't think there's any other way of putting it. It's an abuse of the language. I suppose you could, I'm not a critical legal theorist. It's possible that a critical legal theorist would say, consent, that's all, tosh. And people can consent to be forced. But for myself, that's an ideological claim. And the content of the ideology is this, that now force has been equated with exploitation of vulnerability. And it's very clear in that section. So one of the circumstances which I have regard to in deciding whether this is forced labour is those circumstances which may make the person more vulnerable than other persons, so that even if such a person consents, we don't have to worry about their consent because they were more vulnerable. So this is an offence of exploitation of people who are more vulnerable than others. And we could argue about whether that's appropriate, but even if we say that it is, Parliament has made the further move of defining that as force. So now to exploit someone as vulnerable is to coerce them, and that the sexual, that's kind of floating in the background of the Sexual Offences Act, but now it's right up front in the formal terms. Coercion is exploitation of vulnerability. Exploitation of vulnerability is coercion. So coercion and exploitation elided, and that I think has some really fascinating and probably unintended implications. But that arises in the next question. So
right. So I guess that's a question, really, right? I mean, so a lot of us who work in the area of trafficking are quite irritated with the use of the criminal law in this way to address what seems to be, chronic conditions of exploitation, of extreme exploitation. Yeah. And the question always is, where along the spectrum should the criminal law land?
Yes.
Right? And so in this instance, would you think, I mean, given your sort of expertise in criminal law, have you ever encountered a criminal law that tries to address exploitation, in effect, right? And and how efficacious is this kind of move?
I'm trying to think of other examples. The example that springs to mind, because I teach it and I'm very familiar with it, is the Sexual Offences Act, because it seems clear that its intent was to criminalise men who, primarily men, it could happen in a gender neutral or homosexual encounter, but it is primarily the relation of men and women that the law is concerned with, obviously. And it does seem that the construction of the definition of consent in section 74 of that act, that a person consents if they agree by choice, but they must have the freedom and capacity to make that choice, permits evidence to be brought that a person chose but lacked freedom and capacity. And usually the circumstances in which a person will lack, or I don't know about usually, but often the circumstances in which a person will lack freedom and capacity are those where for some reason they are vulnerable to the exploitation of a they're vulnerable because their range of choices is limited in a way that's known to the defendant, to the putative offender, and the offender then exploits that limitation of the range of choices to procure the consent or the choice that he wants, sex in some form or another. And so the classic case would be Kirk, where the 13-year-old girl, I think she is in the taxi office in the middle of the night, and she's hungry and she's got nowhere to go, and the guy offers her something pathetic, £3 for a sandwich, and she consents to have sex, and the court ruled that she agreed by choice, but she didn't have freedom capacity, and that seems, as I understand that, what that's trying to achieve is to criminalise the exploitation of vulnerability in the context of a sexual encounter. There's probably others, but that's the one that springs to my mind. In fact, if I thought hard about that, does the Fraud Act work the same way? No, of course, the other example is extremely famous, is Hinks in the Theft Act. Of course, I knew there was another one in my mind. Do you want to talk about Hinks?
Yeah.
Well, because there it is. Well, this is legal wonk stuff.
Yeah.
This is not policy stuff. But so Mrs. Hinks persuades her neighbour, who's a man of limited educational capacity, she knows that he's inherited £60,000. I think it was a large sum of money. So she persuades him that he doesn't need the money, and she could make good use of it. So she takes him down to the building society where the money's been deposited, and they take it out at the rate of £300 a day or something in cash. And eventually the building society people get a bit suspicious about what's going on. They find out that he's giving her all the money. And she's prosecuted and convicted of theft. She appeals on the grounds that he not only had he consented to give her the money, but that the money was a gift in civil law. There was nothing to vitiate the contract. The contract was a good contract, and if he had gone to a civil court and asked for the money back on the grounds that she'd got it unlawfully in civil law, he wouldn't have got anywhere. It was her money, he'd given it to her. Nevertheless, the criminal courts, up to and including the House of Lords, concluded that this was theft, and it met the legal definitions in the Theft Act 1968, which in itself is fascinating from a theoretical point of view. However, there seems to be Alan Boggs and John Stanton Ive of this august institution, I think rightly identified that what was going on here was that the criminal law was being used to protect the vulnerable from exploitation. It does seem on the facts as we know them that she was exploiting his limited understanding of the value of what he had. But he gave it to her because he didn't value it, so he gave it to her. So yes, and that for I don't know how much theory you want to talk, but if we're thinking about the history of this, I think this is an area I really would love if I had the time to go and study the history, where the 1968 Theft Act came from, that it occurred in all years, 1968, that should be the moment at which this shift occurs, where the theft turns from being an objectively defined into a taking without consent, which is how the Larceny Act defined it previously, to an appropriation, a dishonest appropriation. And although in 1968, I don't suppose anyone had, maybe someone had it, and that would be worth finding out, but I don't suppose anyone in 1968 thought, great, we can protect the vulnerable from exploitation with this. Nevertheless, the substantive terms in which the law was reframed allowed that, which, if I may grind my axe, kind of fits with my broad thesis that it's part winning the debate with Devlin. It's the end. This is the moment at which substantive moral values in the criminal law are not just in terms of it is in terms of its scope, because what the Theft Act 68 does is it hugely expands the scope of theft, at least in theory, from what was how it was defined in the Larceny Act. So and it does so at the outer edge of it. It's still a bit theoretical. I don't know of hundreds of cases that have followed Hinks where people, but the courts have admitted into the criminal law and into the offence that is committed more often than any other. They have drawn in the theoretical possibility that this can be used to protect the vulnerable. And the examples used by Hinks's counsel are fascinating examples of. Where they say, what about someone who knows that what he's selling isn't worth what he's selling at, and he knows the buyer doesn't know. Why doesn't he fall in? So there'd be a good transaction at civil law. He's just exploiting the ignorance of the buyer. Why wouldn't that meet the criteria of theft if Mrs. Hinks does? And Lord Stein says, we wouldn't do that, and he kind of brushes it under the carpet a little bit. I think, and this all comes back to the words in subsection 4a here, the critical bit is that Mr. Dolphin, the victim of Hinks, is particularly vulnerable by virtue of his educational disadvantages, so that he doesn't know the value of the money he gives her, which is the court accepts. Which means that I think in Lord Stein's mind, he thinks, in a trade, of equals in a business trade, the fact that one of them is ignorant of the value isn't the same as Mr. Dolphin's ignorant. He's especially vulnerable, whereas ignorance might make us all vulnerable in some ways, but that's something we all put up with. But I'm not sure that logically it doesn't follow that as soon as you exploit someone's ignorance, you're not exploiting their vulnerability. And I presume billions of trades are going on half a mile from here, in which one side is thinking the other side doesn't know what this is worth, and I'm getting a good deal. That's business. So it's opened up, at least in theory, at the edges. The underlying ideology is one in which sort of opens up, at least at the edges, the possibility of the criminalisation of all the discretionary criminalisation of business activity.
It's totally fascinating, and I think puts the Modern Slavery Act, now has this redemptive glow around it, I have to say. Except that the consequences of the criminalization move is actually not that positive for those who are found to be victims of trafficking. If anything, everything that went on in the negotiation of the Modern Slavery Act seemed to suggest that they were the, advocates had to fight very hard for any sort of provisions for the protection of victims of trafficking. But I think it's theoretically very interesting, and who knows, as the act is operationalized, prosecutions may in fact pursue this expansive idea of exploitation, which actually a lot of progressive, colleagues might actually welcome.
Well, here's the thing. So that was Hinks has just come to mind. I wasn't thinking about. I mean, I knew it was in the back of my mind. Something was troubling me. So you asked, what is the efficacy of the move? I can't address that. It's striking that Hinks doesn't appear to have led anywhere in practice. It's 15 years old, and there's not like there's a great number of cases, but. If the Act's redefinition of force as exploitation of vulnerability has an ideological component, that the norm that's being established is Lord Stein says in Hinks actually, the purposes of the criminal law are just different to the civil law. So there's a conflict between the criminal law and the civil law here. Who cares? We have this different purpose. Now, I think that Stanton, Knife and Boggs are right to say, and that different purpose is protection of the vulnerable. Then that's really what all of these laws are then laying down. That's the normative underpinning of the criminal law, according to Lord Stein in Hinks, and more generally, and certainly my analysis of lots of other offences would bear that out. Mm-hmm. So that's a kind of, maybe we think that's good, maybe we think that's what the criminal law ought to do, but there's a shift in its content, a historical shift in what it means. Now, But then, and I don't know quite what to think about this, it's a genuinely interesting problem. It seems to me that ideological confusion then results in the relation, and this is generally true, but it's particularly striking here in sections 1 and 3. So if you then, section 3 defines exploitation so as to clarify when we have an offence, when we might have an offence. So section 1 redefines force to include exploitation, and then section 3, exploitation is defined as forced labour or slavery. And so what we now know then is that forced labour or slavery is taking advantage of the vulnerable. Okay, so that I think that's roughly speaking where we're at. If you're engaged, or at least you could be doing other things. Obviously, it could be much more forceful than that. Sorry, it includes taking advantage of the vulnerable. Mm-hmm. In which case. It appears that exploitation, and this has occurred to me before just in common sense around this, but now I see it in the legislation, it's interesting. It appears that exploitation has been redefined to exclude ordinary wage labour. I think that's the critical ideological move, that exploitation is what's done to people who are particularly vulnerable, so that mere low pay, or mere pay, as it happens, the old socialist critique of the labour market is erased by the legislation and by the surrounding discourse. So there you have a classical. I don't like the term much, but there's the neoliberal move. We've got rid of all of that tedious socialist critique of capitalism, and now because exploitation is just this terrible moral extra thing that some bad employers and criminals do. But that seems to me to be double-edged. I just think that's a double-edged sword, because now, well, here was what I think. Looking at it, it seems to me that there might be an unintended effect of the confusion here, because subsection 3 says, in determining whether a person is being held in slavery or servitude or required to perform forced or compulsory labour, regard may have to all the circumstances. Now, and here we come back to these words. So, and to regard may be had to any of the person's personal circumstances, and then we get a list, such as the person being a child, the person's family relationships, and any mental or physical illness. That's a such as. And then, which may make the person more vulnerable than other persons. And these seem to me the crucial words. Now, on the one hand, they seem to be intended to exclude the kind of normal business transactions that Hinks is lawyers brought up in that case and say, no, it's only when someone's like Mr. Dolphin especially vulnerable, and something similar is going on here. So if it's a normal employment contract, somehow no one's vulnerability is being exploited. But it seems to me that on the classical account, few workers received the full value of what they produce. So that's what the exploitation meant on the classical account. And you could say that the person who, in a labour market, in any wage negotiation or any labour contract, some people are more vulnerable than others. So a person who has property so that they don't have to work is a good deal less vulnerable than a person who doesn't have any and does have to work. So the language of vulnerability draws in a consideration. So when you think about the personal circumstances, such as family relationships, mental or physical illness, possession of property, it's not included in the list, but it doesn't seem to be an exhaustive list. It's not presented in an exhaustive list. So it would be interesting I wonder, perhaps a response would be to challenge a minimum wage employer on the grounds, a normal minimum wage employer on the grounds that he was exploiting people whose circumstances made them more vulnerable than other persons. But which other persons? Bankers, university lecturers.
Absolutely. This is precisely the sort of legal realist critique of anti-trafficking law, which is to simply say, criminal law is not the way you address these core questions of exploitation, and that actually this is a screen.
Yes.
Effectively,
yes.
And if one tracks down to the EU jurisprudence, the European Convention on Human Rights, on what exactly is slavery, what exactly is forced labor, those are very confined legal concepts, right? So, and vulnerability is introduced here in subsection 5 of the definition of exploitation in the context of force. So, if there's force or threats or deception, right, it's only in that context of vulnerability somehow produces exploitation.
Well, is it though? Sorry, if I've misunderstood, I've missed something then here. The person... So there has to be force, threats or deception before you get there.
Yeah. So historically, the Palermo Protocol actually has a phrase which is unheard of in any legal system, which is the abuse of power or the position of vulnerability, which was apparently introduced by the radical feminists to really catch any kind of prostitution, whether it's voluntary or not. And so I think there are some remnants of those terms in terms of vulnerability that have manifest themselves once again in this act. So there's some history to those terms.
See, there has to be slavery, sexual exploitation, removal of organs, or securing, but these are alls, these are disjunctive persons. So does that effectively exclude the possibility that a minimum wage employee could seek a prosecution and force the Attorney General to discontinue it?
Well, it depends on how those terms force or threat might be. Actually, force is the loaded term. How would you actually interpret that? And the International Labour Organization, the conventions have all had a very rather minimalist idea of forced labour, which is to say under threat of penalty, right? So there's always that sort of, just as exploitation could, traverse from the extreme forms to, the sort of low pay scenario. I think force also traverses that kind of spectrum of possibilities. So it gets somewhat, and because this is getting played out in the context of criminal law, and the victims of trafficking often might not be citizens, which means the remedy really is to send them back home. So it becomes, that's the reason why, the critique of the act could possibly be that, in fact, it's a smokescreen. But I think it's important to look at the doctrinal possibilities, because that's exactly what will get argued in court.
But most people would be in the situation, or practically the bulk of the people who are likely to be victims here would themselves be liable to deportation, probably under ordinary immigration law.
Exactly, which is why they're not willing to come forward to assist with the prosecution.
But then there would be But then I'm doubtful about the functional purpose of the legislation then, since if you uncovered this kind of activity, you could. So it's really aimed at, insofar as it has a policy, a practical policy, it's aimed at the organised crime people who organise it. Although lots of other people are going to be caught up in it, and it allows the police, in addition to the immigration service, to investigate immigrant labour in effect.
Yeah, exactly,
Yeah.
exactly. So I guess what's your, going through, one of the core issues around the Modern Slavery Act that didn't get much press and that many of the NGOs didn't actually engage with either was over the Slavery and Trafficking Prevention Order. There's very little discussion of it. So tell us exactly how these orders work, and what is the history of these orders in English criminal law?
Can I just say one other thing, because about the criminal offences, which is that this sentence is the sentence for the basic slavery, the trafficking offences, is characteristically absurd, or rather grants this huge discretion up to life, and does so in a way that symbolically tells the judge that this is a serious offence, a very serious offence, and this tendency to symbolic severity, and probably this will pull up actual sentences because it's a maximum life offence. Just to make the point, is a further indication of the collapse of the state's moral political authority. I'm fairly sure of this, that as penal severity increases, what you know is that the substance of the state's authority is declining. Strong states do not need severe penalties. So that's just another example of this of institutionalized panic produces these extremely severe responses, or at least symbolically severe responses.
Absolutely.
The orders. Well, where is it? It's classic in form. Section 14, isn't it? Yes, it has all the usual characteristics of what we tended. Well, people call them different things, but I would call them civil preventive orders. It has you need evidence that a person has been involved in the activity you're purportedly trying to prevent, that there's a risk that they will be involved in the future, and that the order is comprised of things of obligations necessary to prevent them from being involved in the order, or to protect people. I can't remember the exact words in section 14, it's one or the other. To prevent harm. And then the order creates a set of individualised penal obligations. I don't think it's a good question whether they should be called individualised criminal law. They don't would seem to me to be better to characterise them as what they are, orders, not laws. But obviously that's a theoretical debate that jurisprudence can have. But they're orders. Individuals are ordered not to do or to do various things, and if they fail to do that, they're committed an offence. I didn't notice, what is it, a 5-year maximum?
That's right.
And that's standard for most, or possibly all of the preventive orders have a 5-year on indictment and 6 months on summary. Yeah,
that's right.
There are two types of these orders: the post-conviction type, of which this is one, and the one that can be imposed either post-conviction or on application. Though this one it does have an unusual element in that it's expanded to include previous convictions. So it's not just available on conviction for a trafficking offence, but if someone has previously been committed, you can retrospectively apply for it later on. Section 16D subsection D, just a detail, was weird. I love this. So, a person is a relevant offender for the purposes of section 15, i.e. a person who is liable on retrospective grounds to one of these orders. And this subsection applies if the person has been cautioned in respect of a slavery or human trafficking offence which has a maximum of life. What's that? Who's going to fall into that category? It's a classic kind of belt and braces. Let's just cover every insane possibility. But it's interesting that Parliament, or the draft, I don't suppose anyone in Parliament noticed that the drafters had thrown this in, but there's a like-mindedness in writing an act which sets up this terribly serious offence and then imagines that someone's been cautioned for it. It's like talking to a university manager, non sequitur, or the Secretary of State for Business and Innovation and Science. One thing doesn't follow from another. Yeah, so it has basically the classic form of, more classic is the wrong word, I suppose, because they're not that old, but it has the standard form of a preventive order. What else can I tell you about that?
So are these against the civil liberties of defendants? Because as I've interviewed many advocates, they had this inkling that these were quite draconian, and I think one of the MPs actually said in the House of Commons that they seem to be draconian. But nobody really, maybe it wasn't high on their list of priorities, but I know there's been a lot of conversations around how these orders match up against the Human Rights Act and the European Convention. So where are things now in relation to such orders?
Well, I suppose there's less anxiety where it's a post-conviction order. It looks like a sentence, but of course it's not. It's in addition to sentence, and it has no, I think logically it has no retributive aspect. It's not proportional. It may be proportional to some things, but it's not proportional to the wrong done in any past slavery or trafficking offence. It's proportional to preventive necessity. So when the court is asked to come up with obligations or to only impose obligations that are necessary, that means proportional to the policy aim, which is preventing harm, not proportional to any harm or wrong done by the offender in the past. So I suppose at the common sense level, at the ordinary political level, there's not much anxiety about subsequently saying to someone who's been convicted of this offence, hey, look, you can't do X, Y, and Z because, look, you did it in the past, and you would just keep away from all of that. Now, you say, well, it is a restriction on their liberty, but I suppose people feel relaxed about that because they've already been convicted tough, you know. It's the more however, it's a yet another example of the fundamental shift of the criminal law, and this is a subject of great theoretical interest to me as someone who proposes that, my claim would be that the criminal law is the shape of the criminal law is the shape of our rights as citizens. It's more fundamental because the preventive orders subject people to state coercion on a purely risk basis, on an assessment of risk basis. And the obligations will be a whole load of things that are ruled necessary and proportionate to preventing them from doing that. Now, if they then do what they're coerced not to do by the state, that may in fact have no relationship to any future offence. So if you're required to, if you're, can you put mandatory obligations in one of these, or are they all prohibitions? Because some of them, they're all prohibitions. So if you're say prohibited from associating with X, Y, and Z, Fred, John, and Mohammed because you were all involved together in trafficking, but actually they were your mates. So one day you say, let's go to the cafe and have a coffee. Might have nothing to do with you might be cooking up some other offence, but you might not be. Now, so we have a liability that's extremely pre-inchoate, and I think that fundamentally. My own view of this is that they are a challenge to the presumption of innocence, and they are the use of the substantive law to undermine the presumption of innocence. Now, the formal burdens of proof all exist. The Crown, in a breach of a trafficking and slavery order, would have to prove that the conduct involved and any other elements of the offence. But what they don't have to prove, because they cannot prove it, is that the eventual harm of any slavery or trafficking offence that they have prevented has been prevented. That's unprovable because you've intervened way before anyone got close to doing it. So I think this is characteristic of the pre-inchoate offence. That's its meaning, is that it uses substantive law to evade the presumption of innocence. Now, it seems to be the view that under the ECHR, that the presumption of innocence is a more or less formal burden. This will it won't be a problem with Article 6 because the prosecution is required to prove the elements of the offence. So the presumption of innocence has a fairly narrow meaning on that basis. It's also the case that the ECHR, as far as I can tell, just doesn't really engage very much with these orders generally. So when we look at all the others, At the margins, with the most extreme, the terrorism control order of the preventive orders, the ECHR did say, well, you can't have secret evidence. That's going too far. But that was something to do with terrorism. That was something specific to terrorism.
Sure.
And it's also limited the capacity to impose house arrest. So if I remember, 18 hours is too much, but 14 hours is fine. I think it's something like that. But beyond that, the ECHR doesn't engage because providing, and the statute, and this statute is the same, the statutes provide that the order must be necessary to prevent crime. Well, if it's necessary to prevent crime, that's going to meet the requirements of the caveats to the rights. So even if it interferes with someone's freedom of speech or freedom of assembly or association or privacy or whatever, it's providing it's necessary, it's going to be proportionate. So the ECHR just doesn't really touch on these, and that's a really interesting. I think that also is, it's interesting and deeply disturbing, because the commitment of civil libertarians to the Convention on Human Rights is profound and almost 100%, and yet the Convention is the vehicle through which the substantive law is being expanded to corrupt and subvert the presumption of innocence. I've tried to raise that on numerous occasions, but people look askance at if you criticise the European Convention of Human Rights, because it's a shibboleth that liberals hang on to. So that's an opinion.
That's great, and you've stated it again, thankfully. So one of the really controversial issues in the Modern Slavery Act had to do with the non-criminalization of traffic victims, and this is where I mean, the victims of trafficking not only had traditionally not had much protection, they were in fact criminalized. So there's Section 45 is a highly watered down version of what advocates wanted in the Act in terms of non-criminalization. So we now have Section 45, and I'm just curious, as a criminal lawyer, how does this, first of all, what do you make of the defense, and how does it compare with other defenses in English criminal law, such as, the defense of duress, because there's an objective standard built into the defense itself, which advocates have been very worried about.
The practical aspect of this is that people who are themselves meet the definitions of victims of forced labour will nevertheless be involved in hierarchical labour organisations, and therefore themselves have been involved in recruiting and organising people who would meet these very broad definitions of forced labour. And so what the reasonableness requirement there in subsection D is doing is just giving the court the discretion to say, no, you were an innocent victim who was just doing the job because you were told to, or although you yourself you were too involved, you were making money out of this or something. So it's to distinguish practically between exploiter and exploited. Logically, what's happening here is that being a victim is being constructed as what we as theorists would call an excuse. So in some circumstances, a victim of the offence has an excuse, and their excuse is being a victim. Now, there's something just logically or normatively very unsatisfying about that your excuse for liability of the offence is that you were a victim of the offence. You're saying the fact that somebody else victimised me is an excuse for me victimising somebody else. My intuition tells me there's a profound wrongdoing there, but I can't explain it.
That's actually interesting, because this is exactly where there's a discordance between criminal law, right? The doctrinal requirements of criminal law, and actually trying to deal with a question that's far more fundamentally socioeconomic. So I'm just curious about do you think the fallout of this is that we need to reconceptualize criminal law, or do we need to re-envisage the division of labour between, say, criminal law and, other laws like immigration law, like labour law, in dealing with problems such as trafficking? What's your sense as a criminal lawyer?
We have far too much of it.
Too much of criminal law,
just generally, and this is an example. But you wouldn't have to go to questions of migration or exploited labour to find that. I mean, this is another example. But weak states throw criminal laws at problems. I had a colleague who's a lecturer in Columbia, and we were talking about the fact that under New Labour, famously they produced all these 3,000 new offences and all of this. And he said, "Oh yeah, that's what the Colombian Parliament does all the time. It's because they can't do anything about anything. They're completely powerless to actually do anything about Colombian society. So what they do, being legislators, is they churn out laws. And so, the British state constantly throws laws at problems, and criminal laws, best of all, because criminal laws have that symbolic, this is terrible, it's wrong, we're against it. You go to life imprisonment for life. We really think it's wrong. And then it will have, as I'm sure people closer to the ground will confirm, these arbitrary effects. They license police intervention into the informal economy or parts of the formal economy, but that's bound to be discretionary. The state's resources next, it's just like drugs enforcement, the state's resources next to the scale of the markets it's trying to deal with are puny. So it will have wholly arbitrary effects in practice. So it's a like the war on drugs, it's a non-solution. We have well-developed the employment law and labour regulation law that should be used, but of course to do that rationally in relation to this problem requires a different approach to immigration, and that's the real the underlying problem. It's not a problem here, is that criminal law is, well, I suppose this is common, what the use of criminal law allows the state to do is have the tail of moral wrongdoing by certain bad, unattractive, exploited, bad people wag the dog of social deprivation, and this is yet another example. The ASBO was a classic. And drugs legislation. The reason the government's unwilling to give up on drugs legislation is because drugs says, oh look, yes, we have these terrible problems of unemployment and family breakdown and wasted lives. It's drugs which are to blame. That naturally they don't want to give that up, and they'd like to have more ways of doing that.
Yeah. Thank you. So on that rather sobering note, thank you so much, Peter, for joining us today. Thank you very much.